The EB-5 Immigrant Investor Program offers a pathway to U.S. permanent residency, but the process is complex and subject to various risks, including denials or delays. Having a robust Plan B is crucial for investors whose EB-5 petitions may ultimately fail or take significantly longer than anticipated. This article outlines viable alternative immigration strategies. Failure in the EB-5 process can stem from several factors, including insufficient job creation evidence, issues with the source of funds documentation, or USCIS policy shifts. When an I-526 or I-829 petition is denied, immediate action is necessary. I-526 denial. The investor loses their conditional permanent resident status timeline. I-829 denial. If filed timely, the investor is usually granted a final hearing or appeal opportunity. Processing delays. Extended processing times may necessitate exploring concurrent options. For high-net-worth individuals who possess specialized skills or significant business acumen, employment-based visas offer a direct path that bypasses the job creation requirement of EB-5. If the investor's home country maintains a treaty of commerce and navigation with the U.S., the E-2 visa is often the quickest alternative. The E-2 requires substantial investment in an active enterprise, but unlike EB-5, the funds do not need to be irrevocably committed pending approval, and job creation requirements are generally lower. These categories are reserved for individuals with extraordinary achievements or executive roles. EB-1A, extraordinary ability, for those at the very top of their field. EB-1B, outstanding professors and researchers, requires international recognition and a job offer from a U.S. institution. EB-1C, multinational managers or executives, applicable if the investor has managed a foreign company affiliated with a U.S. entity for at least 1 year. If immediate permanent residency is not the goal, certain non-immigrant visas allow the investor to reside in the U.S. while maintaining their investment or starting a new venture. This is a highly effective Plan B, especially if the EB-5 investment was made through a new commercial enterprise or an existing foreign operation. The L1 allows a manager or executive from the foreign company to transfer to the U.S. office. Key requirements often involve proving the foreign entity remains active and that the investor has worked for that entity for at least one of the preceding 3 years in a managerial or executive capacity. The L1 visa can often transition into an EB-1C petition later, if the investor has eligible family members in the U.S. Family-based petitions might provide a more secure, albeit different, pathway. Furthermore, if the EB-5 denial was based on a factual error or misinterpretation of law, filing an appeal or a motion to reconsider with USCIS or the Board of Immigration Appeals is a mandatory step before abandoning the EB-5 track entirely. Consulting with an attorney experienced in defensive immigration strategies is essential when facing a denial notice. A successful immigration strategy anticipates setbacks. Investors should assess their eligibility for E2, L1, or EB1 categories before committing fully to the EB5 route, especially if their source of funds documentation is complex or if they have unique professional credentials. Having parallel applications ready minimizes the disruption caused by an unexpected EB-5 denial.